Good evening. Happy Saturday, although you may be seeing this on Sunday. I saw this particular video. I believe James Freeman shouted it out. James Freeman. And, I figured I'd give it a whirl. I'd give it a shot. I have fairly limited criminal criminal defense work. Fairly limited. I've never done any felony stuff. And I've never actually done a trial. I've never taken a case to trial. So, take all this with a grain of salt. But in my experience, the prosecutors and the judges and the public defenders are too chummy with each other, in my experience. And especially prosecutors and judges, because it's like the prosecutor has hometown advantage over the new guy who isn't in that judge's courtroom every day, all the time, hearing after hearing after hearing. And I think that has a detrimental effect. It certainly doesn't have a good appearance to defendants, and I am not at all saying that our criminal justice system is perfect by any stretch of the imagination. Um, it is the best criminal justice system that I have seen. So there you go. But this is this looked interesting to me. Watch defense attorneys conspire against their own client, and judge retires after the video is released. The defense attorneys are Heather Chestnut and Daniel Torrance. And Heather Chestnut and Daniel Torrance worked for the Salt Lake Legal Defender Association. They provide services to indigent clients. They're basically the public defender. And Miss Chestnut was, at least according to this, an employee of, an attorney for the Salt Lake Legal Defenders firm up through May 13th of 2021. May 13, 2021. And now she is with the Utah Attorney General's office, which is a step up for her, I assure you. The other gentleman is Daniel Torrance, and he is still with the Salt Lake Legal Defenders Association. Now, both of these are experienced attorneys. She started in 94. He started in 96. I assume that they both know their way around the criminal courtroom. Now, why did he have two public defenders? I'm going to assume that Daniel Torrance was his assigned public defender and that Heather Chestnut was assisting in the case, I'm going to guess. But from the video, it will be clear that Daniel Torrance is the Luis Sanchez's attorney. The judge allegedly retired after the video was released. The judge was... Does it say her name in here? I believe it says her name in here. Here we go. Judge Catherine... It's supposed to be Bernard Goodman. Judge Catherine Bernard Goodman put in her resignation February 22nd, 2019. And she would be retiring September 1st, 2019. You can see that Chelsea Cock was appointed to fill her position. And this was from August 9th, 2019. So most likely, Judge Catherine Bernards Goodman did in fact retire on September 1st, 2019. And the video came out 10 months ago. Generously, that would be November of 2020, which is significantly after September 1st of 2019. So the judge did not retire after the video was released. The judge retired well before the video was released. And there is nothing indicating that this video or this case had any effect on the judge. The judge has judicial immunity for any decisions made on the bench. So I don't think she would care. I don't think the judge cared at all. Now this gentleman, ASD Docs, he says that this case, boy, there's just so much evidence. We're going to be exposing. He's exposing a lot of different people. Exposing, and presumed him innocent. Yeah. He assured me he had tons of evidence, and as you can imagine, all this guy does is expose videos. At least for my quick perusal of his account, it looks like he does like, oh, these cops are bad. Oh, these cops did this. These cops did that. He is definitely a exposer of cops. So as you can imagine, he would be extremely skeptical, right? Yeah, right. So I've never had a case where this much evidence was presented to me. This much evidence. So, this much evidence. Now, this may be part one. I don't know. It doesn't say part one here. But that would be interesting if there was more. So we will watch the video. What he does is he just plays the video, this video here, and he does a little bit of talking to Mr. Sanchez. But the video that he plays is just this video here off of Mr. Sanchez's channel. And we will go through it. So I guess let's get it going. Pardon me, I've got a cough. I should have had some water or something to wet my whistle. So anyway, let's get her going. Let's call it. All right, so he whispers, "Let's call it and get a warrant." Now, if you see, there's not a lot of people here in the courtroom. This guy right here looks like a defense attorney. This defense attorney looks like he's wrapping up. The defense attorney and the defendant will stand here. These briefcases here are the defense attorney's briefcases. They've passed the bar, so the attorneys sit waiting over here, right? Now, one thing you should always be skeptical of is a video that edits out things. Now, I get it. This would have been a very long video, but we don't get to listen to everything these two people say. Get a warrant. Now, the audio cut out. Why did the audio cut out? She points at the wall. What was she saying, though? Ask yourself, what was she saying? And I'm only being skeptical because ASD Docs, who, as you can imagine, was extremely skeptical, as he said, apparently wasn't, because he just played this video and he just took it, hook, line, and sinker. So I am not saying, by the way, I just want to make this clear. I'm not saying that Mr. Sanchez's version of the events is wrong. I'm saying that there is reason to be skeptical. That's all I'm saying. He may be absolutely right. So she's pointing at the wall. Congratulations. And they're talking. But what were they saying? Somebody says, "Is it time?"
Is it time?
Now, why? Now you're going to ask yourself why he's sitting here, right? He's sitting here. This other attorney's kind of off to the side trying to pile his stuff up here. He's sitting here. He's ready to go. This is the go position right here. These people are ready to go.
8:45. 4 minutes.
So 8:40 current time. Okay, 4 minutes. 8:45 a.m. Now, what time do you think that this particular hearing was supposed to start? Well, both of the attorneys for Mr. Sanchez are here. That's a good place to start. Both attorneys for Mr. Sanchez are here. Now, this is a court calendar for Monday. This is the court calendar for Monday. If I scroll all the way up to the top, this is for Salt Lake City District Court. This presumably is where Mr. Sanchez would have been having his case heard. Now, I have selected 8 o'clock, but it'll take 8:32. And as you can see, there are hearings. There are about 134 hearings at 8 or 8:30 in the morning. Now, if the hearing was supposed to be at 8:30, maybe I could see, Mr. Torrance should have been a little more forgiving as to Mr. Sanchez's tardiness. But if it was set for 8 o'clock, and it could have been set for 8 o'clock, because some of these are 8 o'clock, if it was set for 8 o'clock, then I can see why he might be a little miffed, because he probably has a lot to do. He probably has more to do than sit in court waiting for Mr. Sanchez to show up late for Mr. Sanchez's hearing. And, attorneys, we don't just sit around at court waiting if we can help it. Typically, we have other stuff we can be doing. So he says 4 more minutes, 8:45 a.m. Okay.
45. The Travis case.
And now there's another cut. That was another cut. And don't know exactly what time this is. I don't see any timestamps anywhere, but he says to her, Heather, let's call it before you get involved talking to somebody. Now, if she is, I see a lot of public defenders just hanging around with lots of different cases. She might have a lot of cases that day. He might have a few. She might be doing meet and confers with the prosecutors of the various cases that she's working on. She might be doing settlement negotiations between her clients and the prosecutors. Who knows? Who knows what all's going on? But he's just said, let's call it before you get involved talking to someone, because Mr. Torrance probably wants to go, because he's probably been sitting there for quite some time. Another attorney shown up. Now, if there was an 8 o'clock or an 8:30 calendar, it might have been diminishing or may have been light.
Before you get
A light calendar.
involved with talking to somebody.
Yeah.
All right, so she responded to something, but we're not going to get to hear it. This is just going to be another cut. So now she's up there. She's presumably just called a case. See some meet and confers going on. More attorneys sitting in here. Pretty light crowd back there.
Good morning, Your Honor. Oh, you're ready? Good.
Oh, you're ready? Good. And then a cut. So this is Chestnut, Miss Chestnut. She is taking care of something. (8:45 a.m.) Now, he doesn't actually show a timestamp of this. On other things, he shows a timestamp. He shows a timestamp when he arrives. So there is a timestamp that he can show, but he is choosing not to. And yes, usually when one attorney is coming up, usually the other attorney will go to the other attorney's podium, because the court might have questions or need input from both of them.
Thank you. That's all I'm ready on for now. Thanks.
Oh, wait, right on cue, he went up. And then, see, there's a cut there. There is a cut there that we don't know what's going on. You can see that Mr. Torrance is sitting back here, patiently waiting with his trial notes, or his hearing notes. It's obviously not a trial, but his hearing notes on his cases. She is just wrapped up with something, but yet she's ready. Oh, good. He's coming up, and then she's done. So what time is it now? If he walked up and then they had a discussion, what time is it after they conclude? And she says, thank you. That's all I'm ready on for now. What time is it now? No timestamp. How do we know?
That's all I'm ready on for now.
But see, it just doesn't make sense. It doesn't make sense. And that should bother you, that it doesn't make sense. She comes up, she says, I'm ready. Torrance is still sitting there. Obviously, if Torrance is Sanchez's attorney of record, he would be up at the podium, but he's not. The prosecutor went up, and then all of a sudden she says, thank you, that's all I'm ready on for now. Huh. Something's missing. Something's missing. Something smells a little bit fishy.
Sanchez.
So before another attorney can come up and get their case called, Torrance says, Sanchez. What time is it, though? Show us the timestamp, Mr. Sanchez.
And, Your Honor, Mr. Torrance is here today. We're ready on Mr. Sanchez.
Now, Mr. Torrance just walked back and looked to see where Mr. Sanchez was. He's walking back. He's looking. He's looking. That's the man who's looking. He's looking out through the door into the little antechamber there. He's looking. Where is Mr. Sanchez?
Sanchez?
He even called for Sanchez.
But he always comes in late.
Big shrug. But he always comes in late. This is apparently the prosecutor's head.
82, State of Utah versus Sanchez. Excuse me.
He's not present, Your Honor.
And you don't expect him? Or?
Lowers voice as she speaks into a microphone. She's literally speaking into a microphone. And this fool puts in a caption that she lowers her voice. Oh my God, yeah. She's totally trying to hide it as she speaks into a microphone. I don't want people to hear me as I speak into a microphone. The judge asks because it's 8:45 a.m. But wait a minute. Wait a minute. It was 8:45 a.m. when this dude's walking up. Right? It was 8:45 a.m. when that dude's walking up. She says, good morning. I'm ready, Your Honor.
You're ready? Good.
Oh, you're ready? Good. And then right on cue, the prosecutor walks up. And that was 8:45. And then she's done.
Thank you. That's all
And then she's done. Huh?
I'm ready on for now.
Sanchez.
82, State of Utah versus Sanchez. Excuse me.
He's not present, Your Honor.
And you don't expect him? Or?
How could it have been 8:45 then, with all the cutaway, with her having done something else, some other case having been called, where her and the prosecutor both needed to speak to the judge, and then she said, "That's all I'm ready for," and then Sanchez is called, and it's still 8:45. I mean, theoretically, I'm not going to say Mr. Sanchez is a liar. I'm just saying that I'm skeptical. Because it could have taken 30 seconds. It could still be 8:45, but he's not showing any timestamps. He's not showing any timestamps. Think about that. And he does show a timestamp later. I want to be sure you're aware of that. And he also says that she's aware that court proceedings are not to start until 9 a.m. Court proceedings have been going on. When was Mr. Sanchez supposed to be there? That's the question. And what time is it now?
I'm sorry?
And you're not expecting him to come?
Well, I always expect him, although last time he was not here, and it was only after my secretary called him that he remembered to come, so.
I always expect him, although last time he was not here, and it was only after my secretary called him that he remembered to come. So, how long did it take him to get there? Think about that. How long did it take him to get there? How long did Mr. Torrance wait? Or was Mr. Torrance even there by the time Sanchez showed up? Court records indicate Mr. Sanchez was present with Ms. Chestnut on previous court hearing, which was subsequently rescheduled by judge, Bernard's Goodman due to Mr. Torrance being absent. Yes, but was he there when you were supposed to be there? You were present, but you were late. Was Mr. Torrance present when you were supposed to be there? Did he leave before he got there? Like, people think that attorneys just have all this time on their hands, but there's, generally speaking, lots to do in attorney land.
Mr. Sanchez has a history of coming in very late.
Out of dozens of court hearings, court records show Mr. Sanchez had been late once and missed one court date. Late once, missed one court date. Case had been active for more than 5 years. Okay, there's 3 assertions there. Now, he doesn't show us any of the court hearings, but he says late once, missed one court date, and the case had been active for more than 5 years. Okay. The hearing was in March of 2018. March of 2018. The initial arrest was in 2014. I think it's on this page. In an early December morning of 2014. So if he was arrested in December, the case would have started in, depends on when in December. It might have started in 2015, but this was in 2018. So March of 2018. So at best, 4 years, 3 months, 4 years, 4 months. Definitely not more than 5 years. Definitely not more than 5 years. Late once and missed one court date. Late. Oops. Fat finger. Court records indicate he'd been late to court once and he missed 2 court hearings. Late to court once and he missed 2 court hearings. This says he missed 1. And here he says 2. This is this dude's My Defense Guide. This is his My Defense Guide. This is him. So is it 1 or is it 2? Again, just remember, just think in your head, should I be skeptical? Should I be skeptical? Now he blames it. Oh, my bond company had to call the court and explain that they gave me the wrong date. Well, it's your responsibility as a defendant to know your court dates. It's not your bond company's job. They will remind you because it's their money on the line, but it's not their job to do, or they're not the ones who get the bail revoked, the bond revoked, whatever it is. California has bail, other places have bond, I don't know. Anyway, ineffective assistance from his attorneys.
He has missed a few altogether.
A few altogether. A few would be 2? I don't know. Now remember, he says he acknowledges he missed 2. That doesn't mean that he only missed 2. He acknowledges he missed 2.
So bench warrant?
I wonder if it's still 8:45 because this just said that it's not supposed to start for 15 minutes. Is it still 8:45? Is it still 8:45? Because remember, it was 8:45. It was 8:45 back here, right? Crazy how long
I asked for a warrant.
45 lasts.
What we have the problem for is I still intend on setting this. I don't want to set it for trial until we square away the discovery type issues and stuff, and so he needs to be here for that.
All right, we'll set a bench warrant, $15,000 cash, commenced bond forfeiture.
So what's she saying there? So she's required to, when she issues the bench warrant, she's also required to issue what type of bond it needs. And the commenced bond forfeiture, he's already out on some sort of a bond. So if he doesn't show up to court in a certain amount of time, I don't know what it is for Utah, but if he doesn't show up within a certain amount of time, then the bail company, the company that actually gave him the bond, then they lose their bond. So they've got a deadline in order to get him back in there, or else they lose their money. So there you go.
Cash, commenced bond forfeiture.
Now, she just said the words. She just said the words, right? We don't know what time it is because we don't have a timestamp. We don't know what time it is, though. And she just said the words. But after she says the order, somebody somewhere has to write it. Now, I'm assuming it's either going to be the clerk or it's going to be the prosecutor who's going to prepare the order for the judge to sign. Actually, in this case, I'd bet it'd be the clerk because the prosecutor is, well, a government employee, and so he's going to have another government employee doing it. So there's going to be some delay between the time the clerk, between the time that the clerk prepares it and the time that it gets to the judge. Just saying.
Thank you, Your Honor. That's all I have this morning. If I could be excused.
So he's done. He has work to do. He wants to bounce.
We're going to take him into custody. Hey,
So yeah, that's what happens when you have a bench warrant. When he shows up, you execute the bench warrant.
Steve?
Oh, do you hear the spooky music starting? 8:45, no timestamp. Overcrowded courtroom. People stand between the courtroom doors and waiting outside for seats just to become available. Huh. Yep. 9:07. Do we get a timestamp now? Are we gonna get a timestamp? Boy, I wish I had a timestamp. Hard to tell when he walked in. Hard to tell. Uh-oh, what's the bailiff doing? I'm sure it's something nefarious.
Oh, State of Utah versus Bradford.
What, did he say something? Did he say something?
Oh, State of Utah
What did he say?
versus Bradford.
I don't know, but there's spooky music. The judge deliberately ignores him. The like the judge is like, look at all these people. I mean, this judge sees a lot of people every day. Look at all these people, and he expects the judge to remember him specifically. 9:17. Oh man, I wish there was a timestamp. Mr. Sanchez approaches Mrs. Chestnut. She informs him a warrant has been issued for his arrest, and she instructs him to wait until the judge calls his case again. Okay. Maybe. Who knows? So he claims that he's been standing here the whole time. Oh, wait. Oh, my. Look at this. Do you see what this is? Do you see what this is? This is what's called a timestamp, kids. Is anybody else wondering why this is the first time we're seeing it? I'll tell you why. It's because it's the first time it's useful for him. Excuse me. That's my skepticism showing through. I would posit that it's the first time it's beneficial for him to have seen it. No timestamp and then timestamp. Crazy. Now, he's looking in this general direction. Now, who is he looking at? Is it this guy, or is he looking at her back? Is he looking at this guy? Is he looking at her? Are these two saying something to each other? Are they conferring on a matter? I don't know. You tell me. It looks like she might be talking to him, or she might have been talking to him. And then he responds back to her as if they're meeting and conferring. But no, 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 no. No, no, Mr. Sanchez knows. Mr. Sanchez knows. Mr. Sanchez knows. I don't know why we're doing all this, but there's Mr. Sanchez still standing there. Oh, now he's back there making a phone call. Making a phone call. Mr. Sanchez, came back in, goes back out, makes another phone call. 10:43. Prosecutor Swift decides to inform Judge Bernards Goodman that Mr. Sanchez is waiting between the doors. Mr. Sanchez has been in clear view of the judge, clerks, bailiff, attorney, and prosecutor for the past hour and 36 minutes. Well, no timestamp again, obviously. But this prosecutor has other things going on more than worrying about Mr. Sanchez. And there was also paperwork to be prepared for the bench warrant to issue. And the judge had to sign it, etc. And who knows how long that took. And it's not a priority. Why would it be a priority? Why wouldn't they take care of the people who were at court on time for their hearings before they take care of our good friend, Mr. Sanchez? And why wouldn't the bailiff have arrested him, if the bailiff was aware? Again, the assumption, it's this weird assumption that Mr. Sanchez is so important that all these people recognize him on site. I mean, I'm sure his attorneys do, but the other people, why would they? Maybe they would, maybe they wouldn't. I'm sure this particular prosecutor has a crap ton of cases that he grinds through every day. Mr. Sanchez can now be seen on his phone, unsuccessfully attempting to reach Mr. Torrance. Mr. Torrance is probably what you call busy. Maybe in a different courtroom. Maybe on a different case. Maybe in a client conference. Who knows?
Mr. Sanchez is standing in the lobby there.
Was that one we already called
Yeah.
and issued a warrant because he's always late or not showing up?
Well, I mean, you'd think that if Mr. Sanchez was that important, she would just know and not have to ask.
And we're going to execute the warrant.
That's what you do with warrants. You execute them.
So we'll see if he comes in here, calls his case. So he's probably calling his attorney frantically out there.
He probably is calling his attorney frantically out there.
Because he wants it executed. He's not going to come save him, I'll bet you.
Well, I mean, that would also assume that the attorney could come save him. I mean, there's already a valid bench warrant issued. What is the attorney going to do?
So we're going to execute the warrant. But he's out there, probably waiting on his attorney or something.
Waiting on his attorney. And it's funny because his attorney was there waiting on him.
He's good at what he does. He doesn't ask until he's between him and the door.
And Sanchez gets arrested. Because that's what they do. They execute warrants. The bailiff will arrest you. All right, they march him through, yada, yada, yada. The cover-up. 10:47, the cover-up. Time for them to falsify court records.
Sometime after 9 o'clock. But this isn't a social event.
Sometime after the case was heard, 8:45. Okay, so he's going to use this to try to justify. The judge says it was sometime after 9 o'clock. The clerk says sometime after the case was heard, 8:45. So was there an 8:45 case that was heard? Because if you remember, boom, 8:45. This might be the 8:45 case, kids. Right on cue, 8:45 a.m. No timestamp. Let's just take him at his word. This is the 8:45 case, right? And then
Thank you. That's all I'm ready on for now.
8:45 cases wrapped up.
But this isn't a social event.
This isn't a social event. You can't just show up when you want to.
Just on that 9:30.
38 minutes late.
So that's when the prosecutor says he saw him at 9:38. Now, according to Mr. Sanchez, he was there at 9:08. Prosecutor says he saw him at 9:38. Maybe. Who knows? Don't really care. Mr. Sanchez admitted to being late. So,
So maybe we should call it so that we can document what time he came in.
Now, the reason why she wants to call it to document what time he came in is because to get it on the record. It's not on the record. Somebody has to testify to it in court.
Yeah.
Or state it on the
State of
record.
Utah versus Sanchez.
This is a formality that they're doing just to, in case he wants to appeal it or something.
Okay, Mr. Sanchez, I just want to make sure we see you before you go back. Your case was already called this morning. We just saw you arrive about 10 minutes ago, which would have been
We just saw you arrive. The court just saw him arrive about 10 minutes ago, which would have been a quarter to 11.
a quarter to 11.
I've been here since 9:08.
Well, you did not come to our courtroom until a quarter to 11. This is the third time you have either missed or been hours late. So we issued a bench warrant for you hours ago. We're going to execute on it this time. I believe we told you last time if you were late, you're going to go into custody.
If you're late, you're going to go into custody.
So
I spoke with Heather at 9:17. I was here earlier.
Okay, but you still admitted you said you were there at 9:08. Even if arguendo, you were supposed to be there at 9. You just testified. You just said you were late. You literally just said you were late. The court said, we told you earlier if you were late, we were going to issue a bench warrant. You just said you were late. Well, okay, so why would she ignore his statement? It's pretty obvious why she would ignore his statement. The judge said, I told you previously, if you were late, we were going to issue a bench warrant. Her client just testified, I was late. Case closed, problem solved.
Your Honor, I saw the defendant here. When I first saw him, I recognized him. I looked at the clock. It was 9:38 is when I saw him here.
It doesn't really matter, but okay, 9:38, he was still late.
I'll note for the record that his attorney is the one that called the case, and we've had this conversation at least 3 times.
His attorney called the case. We had the conversation at least 3 times, and 3 times right there.
Could I just know what time the warrant was issued? What time did my attorney leave?
Those are 2 different questions. What time the warrant was issued and what time the attorney left.
you can ask your attorney about that, but we didn't issue it until after 9, and you're here way after that.
So issued it after 9. Who knows? He doesn't provide timestamps. Oh no, here's the music again. Anyway, so that's really the end of it. That's all that really matters. Now, what he did is he pled guilty. He pled guilty, and he did it. There's apparently a method in Utah where you can plead guilty but still preserve your appeals on various motions, various motions that you believe should have been granted or whatever. So this is State versus Sanchez. This was filed in November of 2020. So here we go. Luis Fernando Sanchez appeals the district court's denial of his motion to suppress and his motion for an evidentiary hearing. We affirm. So they're saying that they're affirming the denial of his motion to suppress and the denial of his motion for an evidentiary hearing. A police officer investigated a loud house party after several neighbors called to complain about the noise. As officer drove to the location, neighbors further reported the party had spilled onto the street and a fight had ensued. Still in his patrol car, officer approached the house and saw 15 to 20 people in the street and on the nearby sidewalk. Several partygoers were getting into their cars to leave and others were fleeing on foot. A few of the cars headed toward officer, and he activated his red and blue overhead lights and stopped his marked patrol car. He got out of his car, raised his hands in the air, signaled the drivers to stop. Officer positioned his vehicle at an angle in the middle of the road to convey the message that the road was blocked and the drivers were not to proceed past the patrol car. So he tried to block the road with one car. Sanchez, who was driving one of the approaching vehicles, ignored officers' hand signals and shouts to stop, the angled patrol car, and the flashing lights and drove around the patrol car. Officer reported that he made eye contact with Sanchez and Sanchez was aware of his presence. Officer even slapped the hood of Sanchez's car, making a fairly loud audible noise in an effort to persuade Sanchez to stop and send the message that Sanchez was not free to go. Sanchez continued to drive about a block to a nearby intersection where other officers had blocked the road. Officer approached Sanchez's vehicle after hearing the other officers yelling at Sanchez to stop his vehicle, turn off the engine, and put his hands on the steering wheel. 3 women were in the vehicle with Sanchez. Playa. Sanchez did not cooperate with police commands and refused to exit the vehicle because he didn't feel that police had legal grounds to be contacting him. Officer observed that Sanchez seemed upset and agitated. Sanchez shouted profanities at the officer and suggested they should pepper spray him. An officer stood near Sanchez's lower driver's side window and he detected the odor of alcohol. Officer opened the driver's side door and ordered Sanchez out, and Sanchez finally complied. As officer stood near Sanchez, he could smell the very strong odor of alcohol from Sanchez's breath and deduced Sanchez had been drinking. Officer also observed that Sanchez's eyes appeared to be kind of glossed or glazed over, which officer's experience suggested was a common sign of intoxication. Officer handcuffed Sanchez and walked him toward the patrol car. Sanchez refused to proceed, insisted officer had no reason to arrest him, and he would not get in the patrol car. Officer then asked Sanchez to complete some field sobriety tests. Sanchez failed the horizontal gaze nystagmus test, HGN test, that officer performed on Sanchez's eyes, showing 6 out of 6 possible clues indicating Sanchez might be impaired. At this point, Sanchez informed officer that he wouldn't have the ability to complete the other field sobriety tests. So he said, I won't be able to complete the other field sobriety tests. Officer told Sanchez he was under arrest for driving under the influence of alcohol and transported him to the local police station. At the station, officer attempted to administer other field sobriety tests, but was unable because Sanchez was, in the officer's words, passively uncooperative. Officer then requested a search warrant to obtain a blood sample from Sanchez. Officer listed the following facts. Yada, yada, yada. Those 16 facts. The warrant was approved. Blood test revealed Sanchez's blood alcohol contents to be 0.13%. The state charged him with failure to stop the command of a police officer, interfering with arresting officer, DUI, and having an open container in his vehicle. He filed 2 motions to suppress the results of the HGN test and the blood test. First, Sanchez moved to suppress all the evidence on the ground that the officer did not have probable cause to arrest him for DUI. District Court denied the motion, concluding that Sanchez's failure of the HGN test when combined with the odor of alcohol on Sanchez and his yada, yada, yada. Officer also had probable cause to arrest him for failing to stop the command of a peace officer or police officer, and that the arrest would have allowed the impound of the vehicle and the resulting seizure. Court concluded the warrant was searched, or the vehicle was searched incident to arrest, and empty alcohol containers were found in the driver's area. Search was permissible under these facts, and thus the court denied the motion on 2 grounds when it concluded officer had 1 probable cause to stop Sanchez for DUI and 2 probable cause to arrest him for failing to stop. Second, he said that the officer misrepresented or omitted certain facts, but the facts, I'm just going to breeze through this a little bit faster. The facts were not substantial enough to justify a finding that the officer's statements were intentionally false or misleading, and yada yada. Sanchez pled guilty to failure to stop the command of a police officer and DUI, preserving his right to challenge the denial of his suppression motions on appeal. And so he alleges that the district court failed to. It doesn't really matter. It just doesn't really matter. He lost. Those were the facts that the Court of Appeals determined were the operative facts. Now, Sanchez's version of facts is a little bit different. The case stemmed from a charge that alleged that Sanchez failed to stop at the command of a police officer and was driving drunk. In early December morning of 2014, police had been dispatched near a residence where a party had taken place and where a fight had been reported. When police arrived, Sanchez and multiple other people in different vehicles were in the process of driving away. One responding officer was Jared Carden. In his police report, Officer Carden states that when he arrived near the residence, he saw 3 vehicles getting ready to leave. Officer Carden then states he stepped out of his patrol vehicle and stretched his arms out and signaled the vehicle closest to him to stop. Court records from an evidentiary hearing offer testimony where Sanchez declares he was the second vehicle in line. Okay, doesn't really matter. Sanchez, as well as Officer Carden, state the first vehicle in line had stopped once Carden gave him the gesture to stop. Both Sanchez and Officer Carden then declared the first car in the line drove around the officer and accelerated away. Okay, but did you, Sanchez, do that? Officer Carden claims he was driving the first car in the line. Okay. Fine. Doesn't really matter. The issue is, did he drive around a police vehicle that had its lights on that was at an angle trying to block the road? Did he ignore the commands of an officer to stop? If he did, great. The officer had probable cause to stop him. There you go. And he doesn't also talk anywhere in here about the results of his blood test. Ms. Sanchez and multiple other witnesses affirmed that Sanchez was in the second car. Oh, no! And never saw the officer slam the hood. Oh, no! That means that Sanchez wasn't drinking or something. Sanchez states he was never given a direct order to stop. It doesn't have to be direct. I mean, if a police car turns on its lights and siren behind you, that's not a direct order to stop. But you still have to pull over, right? He reveals that he only drove away after waiting a significant... How many minutes is a significant amount of time? I mean, when do you get to drive away? Believing they were not being sought by the police. Okay, but that doesn't mean that you get to go. I mean, your subjective relief is irrelevant at that point. It's what the officer is trying to do that's relevant. And then the officer's allegations. Awesome. Now there are not evidentiary hearings, there are motion hearings. And motion hearings generally proceed on more relaxed evidentiary lines. So just because Judge Bruce Lubeck determined in a motion hearing that the second vehicle, a Toyota Camry, was driven by defendant doesn't mean that that is what is the facts for trial purposes. So just remember that. Just because at a motion hearing a judge makes a determination of fact doesn't mean that that's what's going to happen at trial. The trial is the trial, and the trial is where the facts are ultimately decided. Now, some other fun stuff. The GoFundMe didn't start until fairly recently. I think this one started in, there we go, July 6th, just recently started. So congratulations to him for, he's $940 out of a $7,000 goal. Now, it's kind of weird because this is from November. When was this? This is from 2020. I think this is like November, December of 2020. There you go, November 3rd, 2020. So he's already suing. He already filed. He has a lawyer, Michael Teeter, who, for all intents and purposes, appears to be a very good lawyer. And his client's alleging legal malpractice and saying he was denied due process. Now, legal malpractice, at least in California, I don't know Utah's version of it, but at least in California, I have been active in several legal malpractice cases, and none of them have really gone anywhere because legal malpractice, at least in California, is pretty tough. You have to prove that you would have succeeded but for the failure of your attorney to standard of care, to meet a standard of care. I don't know why. It's late. I'm tired. So you have to first of all show that your attorney failed to meet the standard of care. You have to show that that caused your failure. The ones I did were in civil cases, so you have to actually prove you get a better result, more monetary value, and that you actually be able to collect on that judgment if the attorney had done things right. It's a little different in a criminal case. I haven't done one, so I'm a little fuzzier on this. I haven't really looked into it. But I know at least in these civil cases, if you accept a settlement offer, that makes it even harder because you have to show that you would have settled for more, etc. I mean, it's a whole complicated thing. So what I'm getting from this, there was no hearing scheduled yet in the case. Mike Solnick is an attorney representing the Salt Lake Legal Defender Association, and the two lawyers said the suit is not well grounded in fact at all. Who knows if it is or if it isn't? Who knows? I certainly don't know if it is or isn't because I haven't read it. I don't want to pay the money to look it up. But here's your clue. Anything where you're suing for $300,000 and your attorney isn't taking it on contingency fee, that's a good sign that you don't have a great case. Oh, that's a guy who's defending him. I don't know why I put that in there. There's Michael Teeter. He's currently a partner at Teeter and Vu. He's general counsel at Represent Us. He was in the Utah Attorney General's office for a year. He worked with Zimmerman Boer. He was an associate professor of law at the Utah S.J. Quinney College of Law, visiting assistant professor of politics and law at Pomona. He was a supervising attorney / teaching fellow at Georgetown University Law Center. I mean, I assume he's going to be a pretty good attorney. I have no reason to doubt that. All the coverage, all the media coverage I could find is just regurgitating Sanchez's version of things. And oh yeah, here's a funny one. Teeter and Vu, teetervu.com. That's weird. Isn't that weird? That's weird. I guess it's still active, but that's weird. What else we got? Oh yeah, there's this one. This one was filed by it shows Luis F. Sanchez and Luis I. Sanchez. And this was filed back in 2014. And he actually got a settlement judgment for $1,000 dues. $1,000 dues. He sued the police. Now, it's not all as awesome as you think it is. The reason why they thought it was an I, not an F, is because that looked like an I, but it's really an F. Anyway, this guy is a sovereign citizen. On or about December 12, 2013, approximately 10:30 p.m., Ruth Ruiz and I, Luis Sanchez, were driving our way home. She was driving. She got pulled over for speeding. He asked her for proof of insurance. He was sitting in the car. Sanchez was sitting in the car. The officer pulled him out, and he was really mean, and he did mean things, and he beat up Mr. Sanchez, and he was assaulted, and oh no, mean things, and then at the end of all the assault, he put Mr. Sanchez's cell phone in his pocket and proceeded to open Mr. Sanchez's door. He was in the police cruiser, and the cell phone fell out. Oh, hit the concrete, made a small crack on the screen. I mean, it still worked, but it had a broken screen. And so I'm going to, so we have look at all these counts: wrongful arrest, illegal search and seizure, excessive force, false imprisonment, assault and battery, intentional infliction of emotional distress, malicious prosecution / abusive process, defamation, damage to property, seeking punitive damages, vicarious liability, respondeat superior. I think it's a Monell claim, whatever. Anyway, they paid him. They gave him $1,000 for his phone, and that was it. Yeah. So there you go. Yeah, I'm not really too thrilled with the amount of research that ASD docs did, but it certainly doesn't appear to be the slam dunk case that ASD thought it was, with the overwhelming evidence of the altered video footage that Mr. Sanchez provided. Anyway, thanks for watching. Have a great day.